it's really good to gather and also reflect on where legal reporting is today. I remember when I started possibly my first interaction about the law with broader public on social media. My handle on Twitter used to be Apar@bar, and a lot of people didn't get that joke, right? It was a pun on the court for the legal bar, right? They used to think that I'm a drunkard. Yeah. So I changed it to my birth year. But what I remembered around that time was that legal commentary, news from the courts was something which is frowned upon. And this has to do a little bit about how the legal institution itself, and I don't mean the courts, I also mean the lawyers and the entire system by itself, how it intersects, prevents transparency, fetters access to the general public. And today, when I look at it, it's so different. And a large part of it has to do with live streaming, live tweeting, reports, dedicated portals, and the growth of public interest in discovering how our courts function, not only the judgments that they pronounce. And with this, I'll come first to you, Manu. Manu, in a recent article, in terms of a retrospective on the entire term of Justice Lalit, you stated that when Justice Uday Umesh Lalit assumed office as the 49th Chief Justice of India on August 27, many would have thought that his term would be a sedate one. But by proving all such speculations wrong, CJI Lalit's term was marked with momentous and unexpected events which unfolded at a quick pace. So you're writing this on Live Law and you're publishing this. Are the primary readers or the audience who's reading this lawyers? Who is this written for?
Live Law is read by, there's a lot of audience for Live Law and also for other legal portals. And if you see the Twitter portals, Twitter handles of Live Law and other legal portals, like you would see that there are like lakhs of followers. And these are not just lawyers. And just with lawyers and judges, you can't have so much followers and so much readership. So legal reporting is not consumed by lawyers and judges alone. It's now consumed by the larger public. There's a lot of greater public interest in court developments and judicial happenings these days. And like from the comments and the responses which we get on a daily basis, most of these comments and queries come from general public and not just lawyers. So that is something, I believe that legal journalism is catering to a wider audience. It's not just to a legal, not just to the legal fraternity. So in that sense, so I think this is coupled with the general interest which the people are feeling, which the people are having towards court developments and judicial happenings. Because courts have now become I would say some kind of a new battlefield on a lot of different issues, on political issues, ideological issues. So people are looking forward to courts, what is happening there. And the court developments and the outcomes of the judicial pronouncements, they are impacting general public also. So it's not something which is very academic. So earlier, if you used to see, the coverage of courts used to be about judgments, and that also used to be happen very rarely. But now these days, if you see, most of the front page news is about court news, and not just judgments, court hearings and court exchanges, these things. So we also realized that, so when Live Law started, we started initially as a platform which is reporting judgments for lawyers. That was the initial framework of Live Law. But gradually, we also realized that, even in a manner which we could never imagine, that our coverage has increased. And a lot of people are reading Live Law, and they are not just lawyers. So we realized that we have to adopt a different strategy also. We have to change our reporting style. We have to simplify it. Because most of when Live Law started, all of us were from legal background, not from journalistic background. Then we realized that since our audience are a general audience, we have to adopt a different strategy. We have to use simpler language. We have to break down the judgments, and we have to explain the impact of the judgment to the people. So that shift happened.
So just a small follow-up question. In the Live Law team, are there lawyers who become journalists, or there are journalists who also become lawyers?
It's mostly like primarily lawyers, but who don the role of journalists also.
Oh, wow. Now, quickly coming to you, Gautam. I think a large part of your writing has been through the Indian constitutional and philosophy blog, and I remember you starting it actually. I remember you tweeting it out, and I think you took it on as a challenge, if I'm not wrong, because it was being stated that the arena of blogging was dead, or it had all shifted towards social media. In terms of the kind of writing which is done on academic blogs, do you think it has an intersection with journalism? And do you think lawyers by themselves, the minute we say that, and I know there's a fair degree of public engagement which we do invite, why are we at the same time so uncomfortable saying that maybe we are also in our legal writing speaking truth to power?
Yeah, I think that, the question is interesting, and I think it has to do with the very specific way in which the Indian courts function. And in that sense, legal blogging in India is fundamentally different from legal blogging in other countries. Because when I began the blog, I was inspired by the culture of legal blogging primarily in the US, where you have SCOTUS blog and you have other blogs like Balkanization and so on. And the purpose is that you analyze judgments, right? And you extract the reasoning, you critique and so on. And in that sense, I think you are basically extending your role as a lawyer into the legal writing sphere. With the Indian courts, actually, if you just look at the judgments, you'll be missing out on a whole lot, right? There's so much that happens in court that is not reflected in the judgment. So much of impact takes place through interim orders, one-line interim orders. The refusal to give a stay, which will be a very innocuous one-line order, actually will make a massive difference to people's fundamental rights. And up till a certain amount of time, and this has now changed, thankfully, but journalists weren't allowed to go up to the front, right? So they had to go stand at the back. And therefore, a lot that would be almost like a bench bar dialogue, and the mics weren't there earlier, right? In soft voices, if you're at the back, you literally can't hear that. And so in that sense, just by virtue of being a lawyer and being given this quite, I think, undeserved privileged access where you're at the front and you're listening to what's happening, would then give you an insight into what is going on in a way that just judgment would not. And I think in that sense, for a while at least, legal blogging was a bit like journalism in part. And I think it's a good thing that now it's changed, because I think now journalists can go up to the front, can carry phones, mics are being used.
Can live tweet.
Can live tweet, yeah. So live tweeting, of course, we can talk about live tweeting, like I think at some point.
We'll talk about that separately.
Yeah. So I think that's now changed for the better, and in that sense, I think bloggers again can focus on sort of analyzing judgments and of course interim orders, but need not take on the burden of journalism, which frankly we are not competent to do. Like there are qualified people who can do that. So.
And Apoorva, I think accessibility is something which shows through your work every time I read a news report. This is one recent one by her. And I'm quoting, "In a high court not very far away, empires of the academic publishing world are fighting to caution insurgency by, quote, rogue websites and, quote, the Robin Hood of science. What's at stake is free access to a galaxy of research and literature in the science and social sciences, and the outcome may have international ramifications." So it's been a few years for you in terms of journalism. What's been driving this passion towards making legal journalism, or what's happening in the courts, much more accessible for the broader public? What drives you? Who's your audience?
Thank you for that question, Apar, and you've really done your homework, I see, for all of us. You're quoting us now. So, see, for me personally, I began with live law. Of course, as a lot of people know, I started with while I was still in law school, just to answer your question about what drives me, and then I'll touch the accessibility bit maybe. So I began while I was still in law school. Live law was still maybe 5-6 months old. It was still, really new. This is back in 2014, if I'm not wrong. So it was still pretty young, and I sort of saw that phenomena rise of course, we've always, if you look at newspapers, if you look at TV channels, legal beat has always been there. We've had quite a few big legal journalists who've been covering the courts for years. We've had Mr. V. Venkatesan. We've had quite a few legal journalists. What happened in the past few years, though, is a different phenomena. It's about, firstly, a lot of lawyers coming together, like Gautam mentioned, because, using their accessibility to courts and trying to bring it to people. And that really opened the doors of the courts to show the sort of action that happens inside. And there's a lot of action that does happen inside. So I think that's where I really started my journey from. Why I moved to the print after that, after a few years, was my idea was moving to a more mainstream audience. Of course, Live Law also has a mix of different sorts of audience, but my idea was just moving to a more mainstream audience, because I think that there's still a certain gap between law and the people. And that accessibility is what I want to really work on. And that's not just because of the language that the law uses. That's one thing, of course. And there's a thin line, I understand, because while you do want to make things interesting for people, which is what I was trying to do in that article, because it was about Sci-Hub and Libgen, the entire controversy. And I wanted to tell people how important that case is. That's just a petition that's pending in the Delhi High Court, but it has massive ramifications and not many people were talking about it. But I wanted people to know about it. And I think that's where my idea of journalism comes from, that I want to bring this entire opportunity that's been given to me through courts opening, through live streaming, through even live tweeting, through just courts becoming more accessible, and taking that to people, because that's where the interaction happens. I feel with the constitution and the law, it's not just within the courts, it's on the streets that interaction happens. It's on a news website that people interact with the law. And that's how if it impacts them, they should know about it.
So now that I know a little bit about all three of your journeys, let me start putting, also when this accessibility is also put to a certain kind of criticism. For instance, and this arouses a sensorial instinct in me. And when I see my YouTube pop up, this lawyer apologized to that judge, and I know it's clickbait because it's an exchange. And we've seen live streaming happen for some time. What has been your experience with now, not as journalists who mediate the information which goes from a court to the wider public, thereby adding context, thereby adding comprehension, to directly live streams being there? Is it actually beneficial in terms of the transparency? And of course, if there are benefits, what are the risks which are emerging now that it is happening for some time and there are dedicated channels which are clipping live streams? So I'll start with you, Apoorva.
Sure. So you're actually right. And I actually wrote an article on this as well, because it was just such a different phenomena again that was happening. I suddenly saw these YouTube channels that had just come up a few months ago, but they had like lakhs of followers, okay? And all they had were YouTube shorts. It was meme content. Judges and lawyers were meme content. There were these YouTube short videos with captions reading, जज ने आज SHO को फटकार लगाई, यहाँ देखें, stuff like that. And they had lakhs of views. I was like, how do they have lakhs of views? But people are interested in these things. Plus, coming to the point of them, actually increasing accessibility, for sure, that is definitely happening. Because again, then, just to understand what was exactly happening, who was watching these videos. I remember Gujarat High Court was the first High Court to start live streaming on YouTube. And I remember going to the first video that Gujarat High Court uploaded, October 2020, if I'm not wrong, which is when they started it during COVID. And I just went through the comments on that video. It of course has
YouTube comments.
YouTube comments. I go through every comment of mine
brave.
as well. Yeah, I do it. So anyway, I get a lot of good feedback. We can talk about that later. But so I was going through the comments, and people are surprised out of their minds. Okay, I remember comments reading where people are saying, I'm a CA, and this is the first time I'm actually seeing how a court functions. I mean, lucky for them that they've never been inside a courtroom before, but still they need to know what the experience is like, right? And people were really surprised. They were like, hame laga tariq pe tariq hota hai, which still happens, but you know what I mean. Like, their idea of a courtroom was very Bollywood. And live streaming actually managed to change that, and people are watching those live streams. They're binging on it. This is This is Netflix content right there. People are really watching it.
So, Manu, I'll come to you now. I think a lot of people have opinions about the law, and they should, right? Now, this with all this live streaming happening, how is Live Law, which is a dedicated news platform, aiming to add value or changing its media strategy to play the function of journalism around it? Or has it been considered inside your editorial decisions?
Even with live streaming happening, so we also had this discussion within our newsroom. So what could be the impact of live streaming in legal reporting? And what we could observe was that even with live streaming, the audience, the traffic in our site, the readership, that was even increasing. For example, the major live streaming hearing happened in a high court, like Gujarat High Court started, but a major case which got live streamed first, which had national interest, was the hijab case hearing in Karnataka. So that was being.
Why is that?
Of course, I mean the hijab issue.
No, what if you notice the hijab case by itself being live streamed by itself, what was happening around it in terms of national attention?
Of course, I
want
mean
to know a
hijab
little
was
more details.
a lot of layers in that issue, and of course, I mean it's very obvious why hijab issue is a very national issue, and so and the Karnataka High Court, they had a YouTube site. They used to live stream all the court proceedings. So the hijab matter also got live streamed. I mean, it's not that just for hijab matter they started live streaming. Live streaming was there always. So when the live streaming was happening, we were also live tweeting, and our tweets were also getting a lot of engagement, and our reports were also getting a lot of engagement. So that was kind of an eye opener for us. Even when the video content is there, people are also interested in reading about it. What is happening? Because everyone may not be in a position to watch the entire video.
You have a point on this?
Yeah, may I just add to that? I also feel like journalists do have a very special vantage point when it comes to reporting on cases, because of course it's being live streamed, but there's more context to what's happening. Plus, I feel like if people are also watching, legal arguments happen in a very specific way that not everybody understands. We feel like people might understand that, but that's not necessarily true. A lot of words that are used, terminologies that are used. So for adding that context to actually understand what's happening in the courts, I feel like, that's when people go to Live Law or come to the print or to read me. They still are interested.
And also regarding you had put this question to Apoorva, like what are the effects of live streaming, and has it really helped, or is it making court proceedings some kind of a tamasha, some kind of an entertainment? That aspect is there. Like you can see a lot of YouTube shorts and reels, Instagram reels made out of courtroom proceedings, and that aspect is there. But on the other hand, I feel that live streaming, that is very educative, and there are a section of people who are taking it very seriously, and which we saw this during the EWS case hearing. A lot of lakhs of viewers were there for the EWS case hearing, and serious audience, and they were closely watching it. The Maharashtra case also, the Shiv Sena case also. If you see the YouTube count, not just the Supreme Court site, many YouTube channels were streaming the hearing. And if you see the viewer count, there are lakhs of viewers for each day's video.
And you were telling me a little earlier that they're very engaged conversations.
Yes, even when we are live tweeting the proceedings also, when we see the comments and the retweets and the court tweets, and people are very minutely following the hearing. And they are not lawyers. They are people from other backgrounds, but they are very closely watching the proceedings. They know what was the question. For example, CJI made a comment, immediately came the replies, CJI made a contrary comment the last day, and now he's asking a different question to the other side. And what is they're closely discussing and analyzing the answers and the proceedings. And it's really, from a very onlooker point of view, it's very interesting to see. I'm watching it in a very somewhat kind of a spectator, what is happening. And it's very, very instructive also, because people who are not, if you see the Shiv Sena case, the hearings are about 10 schedule and a lot of constitutional issues. It might appear very dry and technical, but people know what could be the real world political impact of these arguments. People are aware of that. And these the extensive reporting and coverage, it has in one way educated the people. It has made people aware about the impact of court proceedings. So that aspect is there. I'm conscious of that negative aspect of this courtroom proceedings being made into some kind of a tamasha kind of a thing. That is there. But on the other hand, when we see the positive side, it is a very educative step in that sense. And people are getting, they are getting more aware about the courtroom proceedings, and they are also getting educated about the proceedings.
So I think picking up from the point about impact, one other area I think which was discussed fairly broadly in terms of resisting live streaming and greater mediatization of the court came from the impact on the judges and the judicial system itself. And I'll take this to you, Gautam, in terms of creating constituencies which can lobby the court by itself. And I remember this because it emerged quite organically around the 66A case. And I was a lawyer around that time. And even at that time, there's a person here who warned me about the consequences, who said that possibly, Apar, this may lead to factions being created which may lobby courts through a greater media interaction, which may not only be one way.
Yeah, I think that that is a really great question, and again goes to some of, I think, the pathological features of Indian courts, because the threat or the problem that you're highlighting in other systems where you have live tweeting, live streaming, there is an internal check to that, which is the language of the law, right? So if you look at, for example, the Supreme Court of Kenya, which, where the constitutional cases are live broadcast, over many days, and South Africa, all those places, there is still, a certain kind of expected way in which lawyers and judges interact, which makes it difficult to, take a clip out of context and then use it to, say, fuel something. Yes. Because you're still bound to a certain kind of legal language that resists that kind of sensationalization, right? So, like the Maharashtra case, right? If you're arguing 10th schedule, right, like you will argue in a language and in a vocabulary that, if someone snips it, what will they get from it, right? Like, yes, this case said this, so and so, right? The problem is that in our courts now, that has long been gone. And specifically with respect to certain lawyers, right, who bring cases which are designed to fuel certain kinds of passions. Now, again, if you're looking at the US or South Africa or Kenya, those kinds of cases will be filtered out at the beginning. They'll be filtered out in written submissions or whatever. So you'll never get to court to, for example, recently someone brought to court a case saying that legislate a UCC, right? Now, if someone tried that in the US or Kenya or South Africa, you wouldn't ever get to court. It will be dismissed in chambers. So there'll be no question of somebody going to court in grandstanding saying, my lords, like, implement the UCC, the court saying no, and then that being used to say, oh, look at this court actually is pro-Muslim, pro-Christian, that's why they're not...
Gautam, one question which quite often comes to us, and by us, I do mean us, okay, specifically, it's not vague, is that you have a political bias, you're prefacing a certain kind of progressive agenda towards the court, and which is why you believe in a certain kind of report and analysis, and you think another kind is just picking up from your words, not because they are your words, because they are the right words, inflaming passions. Do you think that there's an underlying constitutional basis to the function of journalism, to the function of analysis, and how it interacts with the judiciary? Is that basis, and this is a leading question now, progressive?
No, so I think that here's the thing, right? So if you look at the court, right, so there is a distinction between a judgment of the court, right, that is delivered after arguments in a final hearing, and between, say, a Monday special leave petition, right, that comes to court for admission, right, which could be a completely absurd kind of a case. It's like this UCC implementation. And thirdly, a comment coming from a judge in the course of a back and forth. These are three very distinct things and are very distinct in the way that they operate. I think the problem is that certain kind of self-proclaimed, say, reporting on the court deliberately conflates these three things, right? So for instance, right? So recently this case involving hate speech, right? So in Justice Joseph's court, right? Now something is going on, and he basically asked the one of the lawyers that, do you know who Periyar is? And he smiled, right? Because there was sort of an absurd thing, right? Like, the quoting Periyar, do you know who Periyar is, right? Innocuous, off the cuff, back and forth in court. Now that was spun into like entire article saying that Justice Joseph of the Supreme Court justifies genocide of like X or Y, right? Now I think that isn't the question of a progressive agenda or like, I think it's just like misreporting, right? So you are taking away the context. This was a back and forth between lawyers and judges. Often judges like and lawyers say things in a back and forth that are off the cuff, right? This is not a judgment of the court. This is not even an order of the court. It is literally like, an off the cuff remark in a certain context. But now that is then you say, oh, the Supreme Court is institutionally anti so and so, anti so and so. And then that adds to like, a prior confirmation bias. The Supreme Court is, woke or like anti this, anti that, right? So I think like the problem is that you're dealing, I think this is the issue, because again, this hate speech case, right? The way it came to court, it would not come to court in this way in another country. There would be like a pleading, a response, there would be a date, you fix a date for hearing, and then the lawyers would come and they would argue in their turn. There wouldn't be this sort of free for all where one lawyer says, look at what's happening in this state, other lawyer says, but why aren't you looking at Kerala, right? So that isn't the way courts are supposed to function. And this is not the way they function elsewhere. And I think because they have become like this in India, this is why you have a situation where the dark side of live streaming or of live tweeting has become this. Because the discourse in the courtroom has lost that internal guardrail that would act as a check against it being used to then inflame like, passions or inflame certain kinds of...
I'm conscious we have been talking only about the Supreme Court. And this is maybe my own bias speaking. I've spoken a lot on this, right? All of us have spoken a lot. So I also want to understand, especially from you, Apoorva, like how is legal journalism looking at the district courts now as capacity grows, as public interest grows?
Actually, you're right, because that's another aspect. When you talk about accessibility, I feel like that's extremely important, that we don't just look at, say, the Supreme Court or the Delhi High Court or the Bombay High Court. We do look at what's happening in the trial courts, what's happening in the districts, because that's where the law is, that's where the procedure is being applied, right? That's where the law is actually taking a form and being implemented, so to say. So, of course, then there are logistical issues that come in there, because we can't possibly have a journalist in every district in the country. But then I feel personally, and that's what I try to do, is I take a very conscious effort to then look at those courts, look at what they're doing. For example, just when you talk about death penalty jurisprudence, and we were talking about this earlier, we of course talk about the guidelines that are coming from the Supreme Court, about what the Supreme Court is saying on how sentencing should be done, whether they're taking a relook. But it's the trial courts that are giving out those sentences. How are they exactly doing it? And it's important to have that sort of analysis, I think. And it's, like I said, it's a conscious effort to keep trying and bringing those stories out as well.
And one thing which I also wanted to understand is that from you, Manu, now, in terms of how are you choosing the cases to report on? Is this distinction Supreme Court, High Court, lower court also playing, or it should touch upon an area of pre-existing interest? How are these editorial decisions quite often being made?
See, of course, there would be some cases of constitutional importance and public law importance would be there. And there would be some cases involving public personalities, for example, politicians or other celebrities. And also like cases involving substantial questions of law. So we would be, and also there are like important PILs to be covered, like PILs addressing issues of marginalized sections and various other issues which may not get a platform in the parliament or in the legislative assemblies because they are not political vote banks. But these people, they have only the court to raise their issues. So we have taken a very conscious decision to give maximum coverage to PILs which highlight socially relevant issues. For example, recently, like last day, there was one case. I mean, the case was dismissed actually. There was a clarification petition filed in the NALSA judgment, uh, like seeking a clarification that the reservation for transgender persons that should be horizontal. Like there is a confusion whether it should be applied horizontally or vertically, and nothing really happened in the case. The bench said that it's already a disposed of case. We can't issue a clarification. The case was dismissed. I mean, dismissed, and they were given liberty to file a fresh petition. So in terms of hearing proceedings, nothing happened. The order also says nothing. But we thought that, okay, this is an issue which should be highlighted. People should know about this. People should know why this demand for horizontal and vertical reservation. I mean, what is the difference? Many people are still not aware. What could be the implications? So we wrote a detailed article about what is the case about, what is the impact. So these kind of issues also we need to highlight. So it's not just cases of politicians, and also there could be high profile cases. Those also we should report. But certain issues which may not get coverage in mainstream media and which may not get raised in political platforms or legislative platforms, we also need to highlight that.
Gautam, just like to, before one final round of questions, which I'll do fairly quickly, it's a short question. Just like to ask you also, as a lawyer, when you were live tweeting, and possibly that was the most visible instance of live tweeting, I think that was the Aadhaar case by itself, which started it. What was the reaction of the legal community? And I think it's important for us to document this today, given that live tweeting is an accepted example. So it's good to go back and think where we may have gone wrong.
Yeah, so live tweeting.
You can even mention what was my reaction. Was I very sportive or was I not?
I think you were a little skeptical. No, I think live tweeting began way before that. I think my first memory of live tweeting is the Kaushal judgment, 377 judgment in 2013, because I was abroad and I remember following it on live tweets. And then Shreya Singhal was like, I think it really caught on Aadhaar PAN, because a lot of people were very anxious because they didn't want to link their PAN cards, and they didn't know what was happening in court. And suddenly, there were live tweets, and I think that was where it really sort of became like a big thing, because people were tuning in to see what was happening. I think
there was a very interesting incident. Somebody was reading those live tweets, right?
There were many people who were reading those.
There's one person who was particularly the day of the judgment, I think. So.
There were many who were reading them, and we were involved in the case. And yeah, I think it was a bit mixed. So I think some lawyers were very. So I remember, for example, that one of Mr. Shyam Diwan's juniors was quite happy. He was saying that the arguments have to go out because these are very important arguments, and without someone taking them out of the courtroom, people won't understand what the case is about. So they have to go out. I think there was skepticism as well. Again, I think primarily on the basis that you're basically, I mean, Twitter is sort of a very specific medium, right? And it's designed to always, by its very nature, accelerate, antagonize, create a situation where everything seems like a zero-sum game. And when you try and reduce complex legal arguments to bite-sized 240-character summaries, there is something that can be lost in translation, right? And I'll give you an example, quite a funny example. During arguments in one of the cases, one of the lawyers, I wouldn't mention who it was, he says that you may want to be forgotten, but the state will not forget you. Right? And what his point was, right? His point actually, and to be fair to him, what his point was that in terms of welfare, the state will not, just because you want to, secede, the state will still take care of you.
Live in a cave, I think that was.
Yeah, right? So the state will still take care of you as a welfare state, right? But when it comes out as a live tweet, right? So-and-so argues, you may want to be forgotten, the state will not forget you. It sounds like the most sinister, evil surveillance state, right? And it wasn't his intention, to be fair to him. And the next day, the newspapers are saying so-and-so says, the state will not forget you. So I think in that sense, there is a certain context to court exchanges, which you can understand the nuance if you're in court. But when it's in written form, something can get lost. And I think there was skepticism because of that.
Gautam, I'll stop you there because I have just one final question, 2 sentences. If journalism is speaking truth to power, what is legal journalism speaking truth to, or who?
See, I believe it's about making our courts accountable and transparent. And when you have, because see, we don't have any institutional mechanism to ensure accountability of judiciary. So judiciary is basically, it's an institution which is founded upon public trust and public confidence. And it's about a perception. So when public can form that perception only if they have that raw material of what is happening in the court. And also commentators like, for example, Gautam, he comments and he criticizes and analyzes courtroom proceedings. He also requires that raw material of what is happening. So we are providing that raw material of what is happening in the court, what is the news, what was the exchange. And so we are finding a meaning in that service. So that is something which I believe. And also one more thing I would like to add. We are also creating a record of what happened in the courtroom. For example, like a lot of arguments and a lot of things which happen in the courtroom, they don't get recorded in the judgment. And so there has to be a public record for many things. Now, recently the Supreme Court has started this practice of publishing the live transcripts. But that is only a recent development. For example, in the EWS case, a lot of things were said. Everything is not getting discussed in the judgment. Dr. Mohan Gopal, he was one of the lead counsels. So he told me that he was very happy with the reports and tweets and everything. So he said that like they were quite sure about what was going to be the verdict. They were actually surprised that there was a dissent of 3:2. And he said that most of the arguments were raised for posterity, so that a future generation can understand and can analyze what happened. And also a lot of things were said so that a wider people, court was used as a platform to appeal to a wider population, a general audience, to make them understand what were the issues with the EWS system. And so by reporting that, we are creating a record for posterity. So that is also another service which I believe we are doing.
Apoorva, I'll take the same question to you.
Actually, +1 to whatever Manu said, I do agree with what he's trying to say. Plus, for me, in addition to whatever he said, like he said, it's about record keeping, accountability, transparency. It is about taking those facts and presenting them to the people, at least for me. Presenting them to the people for them to form an opinion then themselves. But they need to be shown the entire picture. For example, if you're talking about, say, a law like POCSO, you can't show people the entire picture by just talking about one judgment or just the parties or the courts. There's the CWC, there's the families involved, there are support persons, and that's what will give them the complete picture. So that's one, and also about taking the law to the people. Like I said, I might sound like a broken record by now, but it is, for me, it is about taking them to the people in as many forms as possible. You like stories, articles, I'll give them to you. Like videos, I'll give them to you. Like, okay, not English videos and Hindi. In fact, I started doing Hindi videos because, so I come from Kanpur. I'm the first person to actually go out and study, and I did my law. And I started making these videos for starting with live law and then went on to the print. And my mother would watch all my videos. She can't understand English. She'd always watch them, okay, always. So my point, then that's when I sat down and I thought that, okay, then, but there is an audience beyond that English audience, right? There is a wide audience there that wants to get to know about the law, that needs to know how the law is impacting them, how courts are impacting them. So fine, I will sit down and it'll take me a bit longer. I've never studied law in Hindi, but I'll make videos in Hindi as well. So for me, it's that bridging that gap as much as possible, as much as possible in my capacity.
So we have very little time. We've run over, actually, so I will just be taking about 2 questions now. Please feel free to prompt certain questions.
Good evening to the panel. I'm Sahanubhuti Krishnan, an undergraduate student at DU pursuing journalism, and I'm planning to take law further and further going into the field of legal journalism. So how do you feel, and what suggestions will you give to me as, or students? I have many friends in pursuing journalism currently will take up law further. So how do you see this field soaring in future, and what are your suggestions?
See, I believe legal journalism is still in its nascent stage, and its peak is yet to be achieved. So there is a lot of scope for legal journalism, and as Apoorva and Apar were mentioning, the present coverage is only confined to Supreme Court and the high courts in the big metros and cities. And what is happening in the Mofussil areas and the lower courts, that is completely unknown to the public. So there's a lot of blind spot is there in legal journalism. A lot of areas are yet to be covered. And as for suggestions, you may be a good lawyer, but that by itself may not make you a good journalist. So you need to have a good sense of law as well as a good sense of news. And what is news? And news is not just anything which is catering to public interest. Deepika Padukone's wedding, or like what she wore in the wedding, that might be an interest of that might generate public interest, but that is not death of a manual scavenger might be a more relevant issue. So we need to highlight issues, and we need to understand how law and how the court system is impacting public. We need to make them aware about that. So that sense should be cultivated. That is something which I feel.
Hello to the panel, I'm Medha. I'm currently pursuing political science honors from Janki Devi Memorial College, TU. So I have a question because, ma'am, you talked about accessibility. A lot of times what actually happens is that all the judgments that is taking place in the courtrooms, a lot of times it do affect, most of the times it affects the marginalized sections who actually do not have access to even social media in the first place, or even Hindi, like you're saying, because, English and Hindi. A lot of regional language is not considered. So don't you think like an effort should be made in that matter, that, judgments are available, and it's more broken down in terms of language too, because what terminologies, even if I as a student can understand, people from that community don't understand, and that is about them. So if I am actually fighting for them, they should be actually able to understand it better. So if you could just highlight, tell about that how can we overcome this obstacle?
No, absolutely, you're right. I agree with that, which is why I was talking about the constraints that we often face. We try to do as much as we can in terms of taking the law to the people, making them understand what their rights are. But I also feel this is also about an intersection between how we, say, interact with not just other journalists, but with the civil society who has maybe inroads. So it's a lot about that. Plus, I agree. We've spoken about Twitter a lot here, but that's also drilled into my head through my newsroom, that we have to always tell ourselves that Twitter is not our world. It's a bubble a lot of times. Not everybody is on Twitter, so we need to get off it and then write. And, that is where the interaction also comes into the picture. So yeah, I absolutely agree. And we just wish that we can do more in that aspect for sure.
So one final question from there, because I've done two. Who's there?
Hello, my name is Rishika Singh, and I'm pursuing journalism and mass communication from WIPS Delhi. So my question was from the whole panel that sometimes legal journalism spirals into being media trial. Like, we have seen that people starts making opinion and they're like that this is correct. This makes a particular party very weak and the other one very strong. So like, how do you ignore it, and like what's the solution for that? Like, people, the media platform use it as a weapon actually against if there is a particular political party involved. So they try to suppress it or make a particular opinion, and it creates a propaganda. So how, as a legal journalist, if you're a honest legal journalist, how you ignore it?
Okay, so that's a wider media accountability issue. If I can just weigh in here, I don't think so. Legal journalism has faced the pressure for those eyeballs to go towards that direction here. It's still nascent, and it's still discovering the domain in which it operates. But I do see some signs that it may veer in that direction, and that comes more from how citizen journalists, quote unquote, operate. And on citizen journalism, there was a senior editor yesterday who did point out opinion. He said that we don't have citizen doctors and citizen engineers, so maybe there's a need for formal training, which goes towards the professional function of a journalist as well. I'll request that, okay, just what, yeah. Okay, I keep saying this, but no more after this, yeah.
Hi, my name is Lakshmi and I'm a lawyer. So my question is for, everyone on the panel. All of you have mentioned that there's very little when it comes to trial courts, because we see more of appellate courts, especially the Supreme Court, that is being given a lot more attention, and even in terms of live streaming and so on. There are also reports that I know, for instance, Live Law does, that I know the print does, on empirical research and its findings from trial courts. What is the impact that these reports have had? Like, do you think it has a wide reach? Are people interested to know what trial courts are doing, and are people interested in empirical findings?
So I'll quickly say print has done a fantastic series of stories about women in trial courts as judges, and also as people who are within the legal apparatus. That's been great, and I think a lot of people are reading them. Apoorva, would you like to?
So our experience has been that there's a lot of interest in these trial courts as well. And it's the same idea, right? Why did we see a boom in people watching live streaming or following court coverages? Because finally the gates were wide open and there was this curiosity in people to just know what's happening inside those buildings, right? It's the same thing for trial courts, and that's what we're trying to do now, to open those gates and show as much as we can at least. And so, yeah, in our experience, that is a wide readership and interest and curiosity there.
Just adding to that, so Live Law, we had started a series for highlighting the infrastructural issues in trial courts. So like wherever we could go, we took the pictures, everything, and we did a story, but we could not continue it due to logistical issues. So such kind of stories, they do generate a lot of interest. And at least people like who are higher ups, they sit up and take notice. And now infrastructural issues of judicial infrastructure, that is one of the highest priority issues for the judiciary now. So they do generate interest, that's true.
And I'll just like to add, lawyers have time to wait before their cases are called out. And quite often I see them scrolling a legal platform, if not playing Snake or one of the other games which are available on their phone. So I do think that happens in the trial courts as well. Okay, thank you so much. Please join us for tea outside.